All right, good afternoon, everybody. I hope everybody is feeling well. It's a nice sunny day. So we have a lot of material to get through. Diana mentioned you can ask questions. I won't be looking for the questions, but she will be looking for them. And to the extent it's feasible and isn't slowing us up a whole lot, I want to try to answer questions about the topic I've just talked about, because I think that really works best for both the questioners and for the rest of you, rather than waiting till the very end. If we start to fall too far behind, we'll change that. All right, so what are the basic questions? The first questions that I'm often asked, or real estate attorneys are often asked, or corporate attorneys are asked, well, you know, why do we do due diligence? Is because the banks require it, or what's the whole reason? How do you do it? And sometimes clients, especially smaller clients, say, why do I need another lawyer in this transaction? All the good commercial real estate lawyers I know to call on me when there's an environmental issue or even a likely environmental issue. And so no one should ever feel, no real estate or corporate lawyer should feel somehow that, you know, they're going to look bad in front of their client because they don't know how to answer environmental law questions. But sometimes this has to be overcome. Why can't I just order a phase 1 environmental site assessment myself? That does happen all the time. Clients do it all the time and sometimes pick the wrong consultant because it's a consultant the bank says is good. Well, banks often, not always, use the least expensive consultants, some of whom are good and some of whom are not good. All right, regulatory routes of environmental due diligence. This looks very detailed, but I'm giving you this for a reason. Number one, the most important law is the Federal Superfund Act, which was first passed in 1980. And you'll see that that is when the first defense to a Superfund action came, and it was called the innocent landowner provision. It took a while for Congress to help change the law. In 1986, the Superfund Amendments and Reauthorization Act, SARA, developed something called an all appropriate inquiry standard, left undefined, but it was all appropriate inquiries into the past uses of the property. So get that, if you have that concept in mind, before you buy the property, you got to do some kind of due diligence. You have to make certain kinds of inquiries in order for you to be able to say, I'm an innocent landowner. You can't buy the property blind and then find out there's contamination and say, oh, I'm an innocent landowner. So that's what that was about. And then the standard practice was developed by ASTM. That's a private standard setting agency. First, they did it in 1993 for phase 1 environmental site assessments. And then there were some revisions. 2002 was the first definition of the very, very important protection, even better than innocent landowner defense, is the bona fide prospective purchaser exemption from liability. EPA didn't come out with a definition for another few years, 2005. But the reason I mention all these is another reason too. Sometimes I'll see a draft contract and it'll mention the Superfund Act, and it'll mention the First Amendment in 1986. And you guys all know the rules. You mention one amendment, but you don't mention the other ones. That means you're excluding them. So I always change that provision to say, and all amendments there too after the definition. All right. So two basic elements in the due diligence process, environmental due diligence. One is the contract drafting portion, and the other is the site assessment. We're going to discuss both of them in about equal measure today. The contract, of course, on the environmental side, does the same thing on environmental issues that it does for all the rest of the deal issues, namely allocates the liabilities and responsibilities consistent with the business deal. Of course, you're always going back to the business deal. What are the parties trying to accomplish? And for that, you need the proper representations, warranties, and sometimes covenants and indemnities. Forms won't do it. I'm so often given, oh, this is the form we last used in some other transaction. And sometimes it's a form that was used for the other party to the transaction. And a harried real estate or corporate lawyer doesn't always remember who the prior client was. Anyway, you can't work from forms. You got to look at the context. As I said a moment ago, what are the parties trying to accomplish? All right. I'm going to give you definitions of site assessment in 3 or 4 different ways slowly as the slides go on, because hearing it once doesn't do it, I don't think. So the basic thing about the site assessment is it's to establish the baseline property conditions of the property. And by the way, I am focusing initially mostly on real property transactions. Many, but not all of the same principles work for a corporate acquisition. And I'll try to point out some of the differences later on between the two kinds of transactions. In our society today, as most of you know, even if you don't deal with it in your day-to-day practice, we are awash in this society now with private equity money, and private equity money is looking for ways to spend its investors' assets, its investors' money. And so I'm seeing way more corporate deals than I have for many, many years. And the corporate deals are actually outweighing the real property transactions, which I have never really quite had that in my own practice. I had that when I worked for other law firms. But so we're going to focus again mostly on real property transactions, and most of these principles apply for the corporate acquisition. So you want to establish the baseline property conditions. You want to get that bona fide prospective purchaser protection, that exemption from liability. And then if you're the buyer, you want to plan how to, well, actually both parties want to plan how to remediate and otherwise deal with problems. You got to get that into the contract. Obviously, you can't wait till you find out there's a huge problem, because the parties are never at that point going to agree on how to remedy them. Okay, so this exemption I mentioned for liability, this is terribly important, both because it's a statutory exemption going back to the beginning of the 21st century, but also because there have been some adverse court decisions that in which the courts seem to look for a gotcha way of defeating a claim that otherwise superficially or facially appears to be legitimate for why the party should be considered a bona fide prospective purchaser exempt from liability under Superfund. So the courts are looking closely at these criteria. So all the disposal of hazardous substances have to have occurred before acquisition for you to claim the exemption. You have to have done all appropriate inquiries into previous ownership and uses of the property in accord with good commercial and customary standards and practices. That's what the Phase 1 environmental site assessment is, the key document, because it embodies, it carries out what all appropriate inquiries are. And it's been blessed by EPA in various forms and by the courts. When you do find some hazardous substances, that's what HS is, hazardous substances or petroleum, it's not the same thing, found at a property, you have to take some reasonable steps to stop the continuing release or migration. You have to prevent the future release and limit exposure to those released hazardous substances or petroleum. None of those are remediation, mind you. You may, if you're not really focused on this, you may say, well, it sounds like you got to do remediation. No, doing these things that I point out in this slide is going to cost you a small fraction of what it would actually cost to clean up the problem. So understand that from the beginning. You've got to cooperate with the response authorities. That means the government, whether federal or state. You have to cooperate with information requests that the government or even private parties that have agreed to pay for the cleanup, maybe because they caused it 20 years ago, or for whatever reason it may be, private parties are doing it. You got to cooperate with them. You have to comply with land use restrictions and institutional controls. So if there's a restriction against using groundwater and you decide that it's cheaper to use groundwater than to pay for public water, I'm going to lose your exemption from liability. So you don't want to do that. And there's one other thing. I'm going to try to move on. All right, contract of sale. What do you need? You need definitions. And I'm just pointing out some of the main areas when that may be counterintuitive. So for example, I mentioned hazardous substances before. That's the term of art in the Federal Superfund Act. But in the contract, you want to use a more generic term, hazardous materials, because that will include things that are not in the Federal Superfund Act, contaminants, that is, that are not in the Federal Superfund Act, such as petroleum. thanks to the wonderful oil lobby that has existed in this country for decades, they managed to get petroleum excluded from coverage in the Federal Superfund Act. So you got to include in your contract hazardous materials to encompass things like that. Environmental requirements, I sometimes do this. I try to do this, and sometimes I have to argue with counsel on the other side. And the concept, they typically say, well, we only want to comply with laws including statutes and regulations. That's it. But as it turns out, lots of environmental regulation, as practiced by regulators, federal and state, does not come directly, it's indirectly from a statute or a regulation, but it's often in a guidance or some kind of commissioner's memo or whatever it may be, but it's in something that's not a legally binding document, seemingly, and yet if you're going to get any kind of approvals, you're going to need to comply with it. So I'm just giving a few examples here. Environmental claims, the most important thing, if you're selling your client's selling the property, and the buyer says, I want to be able to get out of this contract between contract signing and closing and get my deposit back. If there are environmental claims, and you, the seller's attorney, say, well, we're going to define what's an environmental claim, and typically you want to have it meet some threshold. The easiest one is, but it's easy most of the time, is dollar limitation. So something that's going to cost the buyer $5,000 or $10,000 or even $25,000 to fix should not be enough in most transactions for that buyer to get out of the contract and get their money back. So you want to put a threshold that's a dollar amount, or that you define. I mentioned it has to have a material adverse impact on the property, but of course parties won't always agree what that means. The other way is typically to say a claim has to be something that the government agency, the environmental agency, would be likely to require the property owner to do something about immediately. And of course, some kinds of violations or inadequacies don't rise to that level. The government is not going to pay attention to it. All right. So representation and warranties. I did look briefly at the list of attendees, and I know many of you are real estate lawyers or corporate lawyers. Some of you are not, and maybe you're more general practice lawyers. So forgive me for going through some basics, those of you for whom this is your daily bread. A representation is a statement about a condition of the property or a condition of the party that's making the representation. And a warranty, of course, is a promise that the representation is true. So you want to put in environmental representations typically especially in the, I find more in the real estate transactions than the other. And having representations and even warranties, of course, is not a complete substitute for an indemnity provision where that seems appropriate for a variety of reasons. And it's not a substitute for environmental assessment. In other words, you can't strengthen contract provisions and say, well, now I don't need to worry about doing the environmental due diligence. Wrong. You really have to do, and by the due diligence here, I mean the site assessment. You must do the phase 1 environmental site assessment. And I give some examples here of representations. You know, the typical in real estate, an inducement to purchase the property. Oops, I didn't mean to do that yet. A representation by the seller that there are no violations on the property, no environmental violations, and or that the property is operating in compliance with laws. More generally, there's always a general provision about the property or asset being in compliance, and that if it's a property or an operation, a business that has environmental permits, which it will if it's an industrial property, depending upon the nature of it, it may have some permits. You want to the buyer want a representation by the seller, of course, that all required permits are in place. One of the things most argued about is when the buyer says, I want a representation from you, Mr. Seller, that there are no hazardous substances or hazardous materials or hazardous operations. And of course, if you're advising the buyer, you know, your client may say to you, well, I didn't put any hazardous substances on the property. And you, as the good attorney, say, well, maybe somebody did before you owned the property. So you can't make a representation about the condition of the property overall. You don't really have a basis for it. Even if you did your own phase one environmental site assessment when you bought it 10 or 15 or 20 years ago. So, but buyers don't want to completely walk away on this issue. So you have some kind of compromise position, which is that the seller says, well, in the time I've owned the property, I haven't deposited, I haven't released or discharged any hazardous substances or hazardous materials on the property. Okay, that's one reasonable way you can partially satisfy the buyer's concern. It's also a question of, well, what are you requiring of the seller? In other words, what does that representation represent? What the seller remembers in his memory, which for problems like environmental problems, typically is not a great basis on which to make a representation. So it may be qualified by after a review of files, that kind of thing. Now, certainly you want a representation that there are no outstanding notices of violations in the environmental arena, as in others, but also sellers often will know that, well, they've got a violation. Nobody's sent us a notice of violation, but I know that there's some aspect of my property or my operation that's not in compliance with the law. So I, as the buyer's attorney, will want to manuscript that part of the contract to say no notice is a violation or reasons to expect one, or in some language like that. And there are some tricky issues with asbestos and PCBs because they're defined differently at the federal, state, and even New York City level. New York City defines, believe it or not, asbestos differently from the state of New York. The state of New York and the feds, the standard is if the asbestos is friable, means it can be crushed by the hand and it becomes friable. Whereas New York City, it's a higher threshold in effect, because if it can be released, if asbestos fibers can be released by machine pressure, then that's also asbestos-containing material. So what does that mean? That means that tar, roofing tar, and caulking material, but especially roofing tar and asbestos-containing tiles, floor tiles, ceiling tiles, that can be asbestos. That's all you have to kind of know about that. As is clauses, certainly, if anything, these are used more often now in real estate contracts than they were maybe 10 or 15 years ago. But this was the standard for decades before that, of course. And that is to say, the seller says, I'm selling the property as is, where is, subject to whatever condition it's in. I'm making no representations to you, buyer, and so forth. Interestingly enough, the courts have in some decisions, maybe one or two in New York, but mostly outside of New York, said, well, you know, those as-is clauses, they have to be really specific about what kinds of liabilities are being pushed on to the buyer. Under common law, as I understand it, I've understood it always, unless you have a provision like this contractually that pushes those liabilities from the seller who had them onto a new party, the buyer, they're retained by the seller. So courts have said, for that reason, you need to really define clearly what are environmental liabilities, whether it's a generic statement that all laws and under any environmental statute, or you want a list. You can have a laundry list of all the laws, although then you run into the problem of possibly excluding something that's important. But if the seller really wants to shift the statutory liability as well as contractual liabilities, it's important to be clear. And a couple of other matters here. Again, you're going to have these slides, I expect, after the program, so you don't have to scribble all this down, but you can go back and look at it. Pre-closing covenants, typically, what's supposed to happen between contract signing and closing. And of course, that is a function of many things, one of which is what's practical to be done in the maybe as little as 30 days between contract signing or closing, but typically more like 60 days to 90 to 120 days. So typical would be a promise or a covenant. by a party, this is typically the seller, to obtain a no further action letter by closing inactive tanks or doing remediation. Very often there are unused, no longer used underground storage tanks. There's no documentation about their having been closed in compliance with environmental law, meaning there's no paperwork showing that there weren't releases from the tank, or even confirming that all the stuff that was in the tank was removed properly and the tank was then filled with sand or whatever. There's a lot of reasons why you can sometimes still close tanks in place. For example, if taking them out, really huge tanks that are near a foundation of a building would obviously threaten the structural integrity of the building. The government is not going to require you to take those tanks out, so you have to close them in place. Closing them in place means it's harder to figure out if there was ever a leak, because the tank remains in a tank bed that might be of concrete or otherwise inaccessible for testing. So it's a complicated thing. Of course, you as the buyer want a representation or a covenant rather, that the seller has to maintain the representation so that what was true as of the time of contract signing is also true as of the time of closing. Okay, environmental site assessment. No, we're not getting to the site assessment. We're going to wait on the site assessments. Indemnities, you all know what those are because obviously they're not just for environmental law. But an indemnity is typically a full and complete shifting of liability to another. There are many different circumstances in which one of the parties, the buyer, is in a reasonable position to insist upon an indemnity from the seller. Let me give you the most obvious one is where there's an environmental history to the property. Most of the problems have been cleaned up, but not all of them. The seller's having trouble selling the property because there probably are some problems that have not been cleaned up. They can't all be defined in the context of the deal. So the buyer might be the only buyer out there, or the only buyer at a decent price, may be in a position to say to the seller, I want an indemnification for you, because if my investigation, which won't be complete as of the time we all want to close, if that investigation is not complete, and then when it is complete, post-closing, I find out I got to spend $1 million, you're going to indemnify me for it. Another circumstance would be if there's a potential or a strong potential or even a likelihood of off-site parties that may be impacted. Beware buying a commercial or industrial property that is surrounded by residences, because residences means families, families mean children, and parents of children get very nervous about environmental issues of nearby property. So the buyer may be in a position to demand an indemnity from the seller that says, even if you haven't been sued, you seller have not yet been sued by a neighboring property owner, in the event that for the next 5 years post-closing typically, or might be as little as 2 years post-closing, I get sued because now I own the property, you're going to indemnify me. It's not unreasonable under certain circumstances, but you got to evaluate. You can't ask for indemnities, of course, every time. And indemnities help you on, a breach of contract. For example, if you think if the party is not living up to its indemnification, then that's can be claimed as a breach of the contract for failure to comply with the representation or warranty. That'll run from the breach of the warranty, but the action for breach of indemnity runs from the date the party fails to meet the obligations to indemnify. So it's a way of having more protection, that you actually can get some benefit out of a contractual provision. Is there an obligation to defend? This may seem counterintuitive, but you may actually, if you're the indemnitor, you're the seller, say, and you're the indemnitor, you may actually want to have the obligation to defend, and to the extent that gives you control over the costs, because you're paying for the defense, and defensive lawyer, of course, is less in control of the cost, because it may be the plaintiff that causes a lot of motion practice and discovery and so forth. But if you can control the cost, it may be worth it for you, the indemnitor, Interesting thing is that you can have an impermissibly broad indemnification. There's a Court of Appeals case in the last few years that says that. So you always want to add to the indemnification to the fullest extent of the law, and that protects you against a court declaring that the indemnification was impermissibly broad and therefore against public policy or for whatever other reason a court finds. You can sometimes, of course, get financial assurance mechanisms to back the indemnity. If you are the buyer and you're getting an indemnity from a seller, and you know this is the seller's main asset, he's a small businessman or real estate entrepreneur, he's heading off to Florida, and those proceeds are going to go to his LLC or corporation, and then they're going to be transferred to him personally, you're a little nervous about how significant the indemnity is and how much it's going to last you. So you might want to insist upon a financial assurance mechanism. Walkaway provisions, typically in a real estate contract, pre-closing, environmental site assessment contingency. And here's where there's often a lot of a negotiation. The buyer says, I want to be, if after my environmental site assessment results come in for any reason or no reason, I want to walk away. Maybe not even related to the environmental site assessment. You as the seller, of course, you're depending upon the circumstances, you may be able to insist that that's too broad. And it is often the case that buyers have reasons having nothing to do with the environmental issues, but they'll wait till the site assessment is finished, but before the due diligence period has ended, and they'll say, I'm dissatisfied with, I've seen this, I still see it in 2023. Not in a contract I've prepared, by the way, but afterwards. I'm dissatisfied with the results of the phase 1 environmental site assessment. What? You're dissatisfied with it? You think you can walk away? Unfortunately, some contracts will permit a party to walk away. So here I give a few examples of what are thresholds. If the if the environmental site assessment reveals the presence of hazardous materials on the sale property or even on an adjoining property in violation of environmental requirements, so it has to violate the law, not just sort of vaguely bother the buyer, and reasonably likely to cause environmental claims, defined term. You remember I mentioned before about monetary thresholds. So that's why you want that monetary thresholds. Again, you're the seller's attorney. You don't want the buyer to be able to walk away because of a $25,000 problem on a $4 or $5 or $10 million property. It makes no sense. That's why you have to define an environmental claim, that threshold, at a level of sufficient seriousness that it makes sense in the context of the deal. All right, existing environmental documents, the seller, this will be in the contract that the seller is providing to the buyer, all pre-existing environmental documents. This is actually good for the seller in a way because it helps the seller organize what it has, quote, knowledge of. Again, knowledge not being what you retain in your brain, and typically for environmental problems or any other kind of problems, you don't want to remember them, so you don't remember them. So that is, after review of the files is what you want in the representation. It's also part of the due diligence process that the seller has to help you, the buyer, in doing. So, that can permit, under certain circumstances, again, a representation about the condition of the property, as long as you have, except as described in documents set forth in appendix such and such, and those documents are all the prior environmental reports. And this is a conventional way that the buyer kind of gets what he wants, which is a representation of the condition of the property and the lack of knowledge by the seller of adverse conditions, except what's in these reports. Transparency is the name of the game in a transaction like this or any other transaction, frankly. So you want to disclose to the buyer all these past environmental reports, especially the ones that show that the problem has been fixed.
Jim, I have a question about disclosures.
Sure.
They're asking if there are any environmental disclosures that are mandated by statute during a sale.
Not on the commercial industrial side, no. That party who asked the question is probably thinking of a residential property in New York we've had for, I don't know how long, 10 or 15 years, 20 years, a disclosure requirement that you can pay a certain amount in a residential property transaction. You don't really have that here, but nobody's going to sign a contract to buy a property without knowing that the seller is disclosing all the hazards. The stakes are not that they're not big in a residential transaction, but they're bigger here in terms of dollars and buying commercial or industrial property is, you don't have these other considerations about, somebody has an emotional attachment, they've developed one, they really want this property no matter what. For a lot of reasons, no, I don't think there's a mandatory disclosure. I may be forgetting something right now, but no. I think the short answer is no. You can have post-closing cost-sharing provisions through an advanced apportionment. Typically, I didn't mention escrow here, but typically, if the stage of the investigation reached at a certain point in the transaction, the consultant says, look, I haven't taken a soil sample. I can tell you, though, what I can see suggests you're going to have a cleanup. So without my soil samples and groundwater samples and soil vapor samples, I don't know, maybe it's a $25,000 problem. Maybe it's a $100,000 problem. Maybe it's a bigger one. Maybe it's a smaller one. And even with a phase 2 environmental site assessment, the ranges may narrow a little bit. Maybe now it's a $50,000 to $100,000 problem after you've taken some soil and groundwater samples to begin to, not fully, but begin to delineate how extensive, the fact that there is actual contamination, not suspected contamination, actual contamination that's been measured in the area where we believe the release occurred, but doesn't tell you how far out aerially or laterally on the property, whether it's in the soil or in the groundwater or otherwise, the problem has persisted. So you only have a range, and so you set up an escrow account so that some of the proceeds of the sale go into a fund that's there to pay for cleanup costs. And of course, lenders will often, almost always require it, and often they'll require a multiple of the estimated cleanup cost. So if the consultant says, well, my best estimate is $100,000 plus or minus 25%, the lender is not going to say, okay, you, borrower, have to put $125,000 into an escrow fund to pay for these cleanup costs. That's not enough. It'll typically be 1.5 to 2 times the amount of the estimated. So here are some other ways that, and many of you who've done real estate transactions, I'm sure have seen these. So you can cap the amount of seller's exposure. Like the seller says, okay, I'll pay for cleanup costs up to $100,000, but you buyer, you have to pay for anything above that. It's very little likelihood, but if it is, I'm only willing to put in a first 100,000. So that's the capping amount of seller's exposure. The deductible amount or basket, that's kind of like the reverse situation. The seller will say, buyer, you've got to pay the first 50,000 of cleanup costs, but because I think that's all it's going to be, and that's factored into the price already. If it ends up costing more, then I'll pick it up to the next level. Typically, a seller doesn't want to say, even if it's 2 or 3 or 4 or 5 times that $50,000 basket. So you'll work that out in negotiations. All right. So insurance, always have to mention insurance. The best form of insurance is really in my third bullet point, pollution legal liability coverage that mainly covers third-party bodily injury and property damage. Third party meaning not the property owner or individuals who are on the property, but off-site properties. You remember I mentioned to you about residences that are in the area of a commercial or industrial property, and they get nervous. So that's what you want protection. You probably have a relatively small likelihood of being sued, but if you are sued and the plaintiff claims their children or child has suffered some serious personal injury from ingesting some contaminant that comes from your property that you now own. You want some insurance coverage, and that's possible. There's also a contractor's pollution liability. I don't know a lot about it, but I know sometimes clients try to get that. All right, so I'm going to give, these are new slides I've developed. I mentioned in the beginning that I'm doing a lot more corporate acquisitions more than the real estate transactions, the commercial and industrial property real estate transactions. So what are some of the differences? And this is just, 30,000 foot view. So think through logically, if it's a stock equity transaction or acquisition of membership interest, you're buying the company. You're buying the liabilities of the company. So it's actually more critical than in the real property situation that all the environmental issues are as fully fleshed out as you possibly can by the time of closing, because the principals or shareholders or members of the company that's now been acquired by your client, the buyer, they're out of the picture. So you can still do things like provide an escrow to take care of some problems, but it's more critical in that kind of case. And for that reason, you're not putting as much effort into the negotiating of allocating between buyer and seller as you are between a more intensely focused environmental due diligence, and make sure that you understand the problems and how material they are to the greatest extent possible. Reps and warranties. One of the first things I noticed in the asset purchase agreements or stock purchase agreements or membership interest agreements is that you have separate reps and warranties from the company on the one hand, from the sellers, stockholders, and the members, and of perhaps greatest interest, in a sense, to this discussion we're having today, the real property owner, especially, or assuming that this lasts, the real property owner where the operation takes place is a related party. And by the way, most of the corporate transactions do involve businesses that by their nature generate hazardous wastes or releases of one sort or another. So I suspect that's another reason why the environmental issues are so intense. Material adversity is the usual standard set in the contract or even in the letter of intent at the beginning for the phase one environmental site assessment to determine the significance of the recognized environmental conditions. That's what RECs are. I'm not sure we've come to that term yet, but we are in a minute. And there's less likely to be a back out provision because there's been much more in the corporate acquisition context, as may be obvious. There's been a lot more business due diligence, overall business due diligence done before the initiation of the transaction than in the case of an individual real property transaction, because the buyer, is acquiring an ongoing business. So they've done all kinds of levels of due diligence, financial due diligence. What's the company really worth that we're buying? So much more than the property is what's the business worth. And so as part of that, there's much less of an opportunity to back out of the deal, and buyers are less interested in backing out of the deal. They'd rather more properly price what's going on. That's my sense of it anyway. Perhaps the biggest single difference, or there were 3 or 4 of them, but is that part of the process is that there will come a time when there will be a 2 to 3 hour scheduled call with the reps and warranties insurer, and that'll be to go over issues identified within various areas. And so typically, of that 2 hours, 15 or 20 minutes might be devoted to the environmental issues. And of course, there's a slightly different kind of exercise that goes on. The phase one environmental site assessment reports or the environmental site reviews, whatever they're called, because in the corporate context, you do a lot of things other than a phase one. Remember, the phase one is for a particular real property. Sometimes the corporate situation, you're not acquiring any owned real property. So you'll get a different kind of environmental site review. The attorney's report to the client is not disclosed to the reps and warranties insurers. So typically the person in my position would spend, would be, I don't want to say more transparent as if you're not being transparent with the reps or warranties insurer, but importantly, you don't want to overly magnify relatively small problems that can be fixed post-closing by the buyer or the new owner of the stock or whatever the case may be, because you don't want to have some exclusions from the reps and warranties insurance that are going to hurt you later on if in fact it's not a likely problem, but a very smallish problem. The other interesting thing about these acquisitions, again, if the private equity money will look, and at least in the deals I'm seeing, will look at particular industries and they'll gain an expertise about that industry. They'll usually retain an outside person who's maybe spent 20 or 30 years or more in that industry to advise them overall in assessing the strength, the health, et cetera, of the acquisition target. And that party will sometimes be involved in the environmental due diligence. And this is basically a good thing because it means that there are typically fewer surprises. The client's not going to say, oh, I couldn't have imagined that that business generates this kind of waste, because they will have known that already from the industry expert that they have hired to advise them generally on the acquisition of a bunch of targets in that same industry. So it's generally a good thing for the assessment process because the client becomes more knowledgeable about typical problems. At least in theory, it can present some issues because that industry person is going to be kind of gung-ho about the acquisition, and it may be harder for her or him to see with a clear eye what some of the problems are. It hasn't really been a problem in the transactions, but I can see the potential for it in a way that I don't see in real property transactions. Site assessments. Why are they necessary? We've talked about some of this, and I'm sorry, a little bit of this is repetitive, but it's worth going over. The scope of liability under the Federal Superfund Act, which you remember I mentioned, is the main federal act that governs liability for contamination on real property. That scope imposes liability on present owners and operators of property, which can be different. So there's joint and several liability for the operator, who may simply be a lessee, but the owner picks up all that liability under the Federal Superfund Act, or past owners or operators at the time of the release. Your client may be called in a Superfund action, and your first thought is, if you don't do environmental loss, my client hasn't owned that property for 30 years, but the historical record has shown that the releases surely or almost surely took place when your client owned the property. Maybe not your client, the landlord that caused the problem or the release, but the tenant you had, the lessee you had at the time. So very broad liability, very limited defenses, and acts of God, acts of war. It doesn't happen that often. There's a third-party defense that is a little complicated to get into. The site assessment requires all appropriate inquiries into prior uses, as we talked about before, consistent with good commercial and customary practice, and that you want to get that bona fide prospective purchaser exemption from liability. All right, so let's go over what happens in the environmental site assessment. There's a site reconnaissance, meaning the consultant goes out on the site and talks to people who are operating there now. We'll also talk to people on nearby properties who may have had a longer history in the neighborhood and can tell you things that you may not immediately see in the written record. So that's the interviews. Historical research or database services that immediately or within 24 hours give the consultant aerial photos, Sanborn maps. Those are fire insurance maps that show underground storage tanks from as fire issues because of flammability in the olden days before we had modern environmental law. Deeds, so you see where the property changed ownership. The consultant will always look for we'll look for environmental agency file review. Unfortunately, you can't always get that in the short time frame in which you're doing the phase one, which might be a 2 to 4 week period. Are there any liens, environmental liens on the property?
Hey, since we only have about 10 minutes left,
Right.
can we give the course code?
That's coming up real soon, but if you want me to jump ahead, I'll jump ahead.
Oh, that's quite all right.
There you go.
There
Here's
we
the
go.
code. Everybody see the code? You'd never guess this one, environment. Okay, let's go back.
Thank you.
Yeah, no problem, no problem. Okay. So the result of the site assessment is to identify this thing that I've used the term a few times, recognized environmental conditions. What is a recognized environmental condition? The definition of this changes every few years with a change in the ASTM standard. You remember I said there's a private standard setting group, the American Society for Testing of Materials, that has really been in the forefront before EPA ever got its act together to define what's good commercial and customary practice. And so slight change in the last few years, you needn't be concerned, but it really has to do with the presence of hazardous substances or petroleum. Remember, petroleum is not part of hazardous substances in, on, or at the subject property due to a release to the environment, or the likely presence now, likely was taken out of that first part of the definition, the likely presence of hazardous substances, the same, due to a release or a likely release to the environment. And the third category is the presence, meaning the actual, not likely or potential, the actual presence of hazardous substances or petroleum products in, on, or at the subject property under conditions that pose a material threat of a future release to the environment. Why is that in there? That's in there because for a lot of reasons, but the main reason I think is that you often have historical fill material that has hazardous substances in it. The release didn't really happen on the property, but there is the presence of hazardous substances or petroleum at the property under conditions that pose a material threat, meaning that historical fill is exposed to the elements. So rain can wash through the historical fill. You may ask, well, why didn't it happen already? It doesn't always happen right away. If you have very tarry petroleum products, which are a variety of such, it may take a decade or two for it to be released into the environment because of precipitation. So that's why I think that's there. Here's some specific example of recognized environmental conditions that usually require further evaluation through a phase two. Underground storage tanks, especially when their closure has not been properly documented. There's not a good paper record. There was no agency oversight. There's no indication that samples were taken of the soil around the underground tank to see if there have been releases. Buried drums or waste, leaks and spill, or oil staining. And the oil staining, of course, is from the consultant walking around the property and using his or her experience to say, that looks like it could be a problem. Remember, phase one, there's nothing invasive about it. No soil sampling, no groundwater sampling, no soil vapor sampling. It's all paper and walking around and talking to people. Compliance audits, I can't leave the conversation without mentioning, there's this other thing called compliance audit. Pretty different animal. It looks at, it's an in-depth examination of facility operations, permits, monitoring records, air emissions. Typically costs 2 to 4 times of what a site assessment will cost because it's very time intensive. It requires a lot of looking at records and permits and agency files. Sometimes they get integrated, especially when it's in a corporate acquisition. The whole company is being acquired, so you really, you might have them in separate proposals from the consultant, but sometimes for a variety of reasons, you'll have them in one. Environmental lawyers and consultants, I know it sounds like a big topic with 6 minutes left. Choosing a lawyer and consultant. I like that there's even a brief biographical introduction. I would have to say most, not all, but most of the good environmental lawyers, at least in the state of New York, have had some agency experience. It's either the US EPA or the state of New York's Department of Environmental Conservation, or one of the enforcement agencies, like the New York Attorney General's office, where I worked. I worked in the DEC. I was chief of hazardous waste enforcement at the DEC. or it can be even at the federal level, the Department of Justice. You're not in the agency that does the environmental work, but you're defending that agency claim. You want a consultant with broad experience, deep experience. You want a smart consultant. You want a consultant. You want to know the kind of work that consultant company gets, because if all they do are bank phase ones and, site assessment light, which is called transaction screening in place of a full phase one, you probably don't have the depth of experience you want. You want to define the scope of the work. You want to have regular contact between the attorney and the environmental consultant. You don't want to give in to a client saying, oh, everybody knows there's contamination there, so just start doing a phase 2 and take some soil samples and groundwater samples and so forth, because you don't really fully know where the contamination might be. That's why you need to at least get to some stage of the phase 1. I'm going to skip these in the interest of time, other than to say that there are reporting requirements. These sometimes become problematic because the consultant representing somebody who doesn't yet own the property is in a bind. Most of the reporting requirements are not limited to the owner of the property, the current owner or an agent of the current owner, but apply to anyone with knowledge, precisely to avoid a consultant for a buyer saying, oh, I guess I don't have to report it. My client's not the owner. That's all I'll say at this point. I gave you the code. All right. The goal from the lender's perspective, I want to spend a minute on this. So you understand what a lender is worrying about in requiring the phase 1. The lender worries about environmental conditions that could affect the value of the property, because the property is the lender's collateral, obviously. And if it's no longer a $5 million property, but a $3 million property because of the environmental remediation that has to be done, maybe the lender has loaned $4 million, and that's an upside down position for a lender. Conditions that could negatively affect the ability of the property to be operated as intended, that there's some kind of restriction, can't use the groundwater, for example. You might not find that out except through the phase 1 environmental site assessment, because there'll be what's called an engineering control in a property or an institutional control. And finally, if the borrower is going to have to unexpectedly spend money doing a remediation, that may impact the borrower's ability to repay the loan. So that's what lender wants to know. Those are probably the 3 main reasons that lenders care about it. And it's important that you know that if you're representing the buyer. Non-scope considerations, sometimes you want to add some things that are not in the standard phase 1. This is a list. Remember this, and when you look back on the slides, this will remind you what's not covered unless you tell the consultant to add these non-scope considerations to the work they're doing. The phase 2 is invasive work, soil and groundwater samples. You want a site access agreement, by the way, if you're the seller, that's important. So phase 2, quickly, soil sampling and groundwater sampling, that's obvious what they are, right? You take a soil sample, you take a groundwater sample. These other 2, not so obvious, so I have a couple of slides in here from one of my consultants that I do the program with. Geophysics, you can have, the most typical is ground penetrating radar. So without going into the ground, you can determine if there are objects, metal objects underneath that suggest the existence of tanks underground that nobody knows about. Vapor migration screening. Soil vapor is something that starts with groundwater, rises up into the soil, and from the soil gases gather and concentrate and can be released into the property, especially into building structures on the property, and cause health problems. You buyer, even if you're a bona fide prospective purchaser and exempt from remediating the problem, you're not exempt from protecting the occupants of the building. Important to understand. Sure, you can go after the guy or the property owner, maybe it's next door, maybe it's a prior owner of the property, to recoup your costs, but you can't wait to protect occupants of your building, and the government is not going to be interested in your claiming you have a bona fide prospective purchaser exemption from liability. So it's important. Soil vapor is important. What does the environmental attorney add to the process? Okay, so the consultant comes out with the phase 1 and findings and conclusions, and typically separate recommendations. What I do is then take that information, I translate it into terms that the business client can understand. both in terms of what's the real risk here, what's a regulator likely to do. Some of that will come from the consultant, but the attorney really does more of it. The attorney also determines whether those phase one findings meet a legal threshold that's been set in the contract, whether it's for cancellation of the contract or to trigger some offsets or payments that the seller has to make or allow to the buyer when they close to pay for things. And then the buyers and sellers' environmental attorneys have to do that negotiation to, where possible, avoid cancellation of the contract and discuss what are the possible changes of the contract. The real estate lawyers are kind of mostly in the background. Sometimes they're in the foreground, but mostly in the background on that discussion, because to discuss it intelligently, you have to really understand it. And it's the environmental lawyers for both parties who understand what's going on. There's different cleanup options. The New York State Brownfield Cleanup Program is something many of you may have heard of. There are tax credits and liability relief. It's a topic for another day. Less well understood is the New York City Voluntary Cleanup Program. Again, you can look back on these slides and get an idea of why these are useful, especially for sites, environmental sites in New York City. So the conclusion is that if you use competent environmental professionals to prevent your client's acquisition or prevent your client's retention of unnecessary liability, and you combine that good contract drafting and good environmental site assessments, you're going to get a deal that reflects the actual business expectations and thus minimizes later litigation. You always want to do that. I've never seen a litigation that has arisen out of a contract that I was able to fully negotiate, I'm happy to say. And you want to keep the government and you want to keep adjoining property owners at bay. And that is my story for the day at 2:02. Thank you all for being such good listeners. I don't know how long, Diana, you can take questions. I'm happy to stay on for another, 10 minutes or whatever is needed. If people want to stay because they want to ask a question. So
Sure, I have just a couple of questions. Whoever wants to stay on can stay on. We'll go for maybe five more minutes. But you did a really good job at answering the questions as they popped in. I kept dismissing them because they would ask and then you would answer them. So I'll ask you a few quick questions, and I just wanted to let everyone know. I just wanted to thank everyone for coming. And this afternoon, I will resend the affirmation, the evaluation, the materials for anyone who may have not gotten them. I read about the ATSM standards for phase one being materially revised recently. Is there anything important we should know about that?
Well, I actually spelled out some of the changes that are in recognized environmental conditions. There may be a few other changes, but I have to admit that I've more relied on my good consultants to tell me what should I pay attention to. Should I read the whole new standard? They said the definition of recognized environmental conditions is the biggest change, but I pointed out what some of those changes are. Honestly, as we sit here, I don't really think they're huge changes. I kind of understand why they're made. I think there's some, here's a big change that I didn't mention, but the big new thing in the last 5 to 10 years has been something called emerging contaminants. And these include dioxins and especially perfluorocarbons. Sorry if I mumble that, but if you go to Google and put PF, Peter, Frank, Oliver, Alfred in, and PFAS, put that in Google and you see what they are. But the really amazing thing is that EPA has already announced, and it is about to go into effect, I think, next month, levels in the parts per trillion that will be excessive amounts of these contaminants, these emerging contaminants, and that they will be added, I'm not sure if this happens immediately or in the next cycle, to the list of hazardous substances under the Federal Superfund Act. So this is perhaps the biggest change. So why is it in the ASTM standard? Because the environmental agencies are requiring that in any cleanup, you have to demonstrate that you cleaned up these PFOAs, as they're called, the acronym, PFOAs and PFAS, to the level of parts per trillion. Ridiculously expensive. just to get the lab results for, of course, not every lab for every contaminant can determine down to parts per trillion. So labs have had to spend a lot of money in the last, 2, 3, 4 years. And that's all going to be reflected in what you pay for lab analysis. So that is whether or not it's actually spelled out that way in the ASTM standard. For sure, that's your biggest change in environmental site assessments.
Okay. In the interest of ending on time, I will wrap it up now. If anyone has any questions that they would like answered, please don't hesitate to shoot me an email. But Jim, thanks again for a great presentation. It was a pleasure
Thank you.
Listening to you, and thank you again, everyone, for coming.
Thank you so much. Thank you, Diana.
Have a great day, everyone.